Hi, this is Roxann Smithers with Smithers and Ume-Nwagbo, your trusted 360 General Counsel, and we're here with a note from our Legalpad. The COVID-19 pandemic has many business owners scrambling to figure out how to respond to the needs of society, their customers, their employees, and themselves. So, in this three-part series, we're going to give you some tips about how you can crisis-proof your business now and in the future. Hey guys, this is part two of our three-part series on crisis proofing your business. In part one, we talked about ways to shift associated risk. In part two, we're going to talk about how to relieve your obligations for fixed cost. So during this COVID pandemic, we see that a lot of both business owners and individuals are looking for ways to reduce their cost and ways to ease the obligations that they have under various contractual relationships. That may be leases, that may be mortgages, that can be other types of debt and other service agreements that they've entered into that now they are looking for ways to trim those agreements or to get out of those agreements. So we're going to talk about some of the strategies that you can use from a legal perspective to ease some of those fixed costs. The devil is in the details of your contract in most of these situations. And we'll talk about three different contract provisions that can come in very handy if you're looking for ways to relieve obligations in those contractual relationships. The first of which is your termination provisions in your contract. You really want to understand and be clear on the circumstances under which you have a right to end your contract, or the ways in which your customers can end their contracts with you. Some contracts have what are called termination for fault provisions, which means you're only able to end that contract early if the other party has in some way failed to perform their obligations under the contract. You may also find that you'll have a termination for convenience or a termination without cause provision. This allows either one or both of the parties to terminate the contract early without either party being at fault. And this is a provision that is often being exercised in this type of crisis in a larger society, as well as if you're experiencing a personal or business specific crisis. So you want to pay attention to your termination provision. More detailed contracts may also have a suspension provision. This gives one or both parties the opportunity to basically put the contract on pause for a certain amount of time, anywhere usually from 30 to 90 days. This gives the party who's looking to suspend times to possibly reorganize, restructure, get some relief from the financial obligations, figure out how they're going to pivot their business before they resume their services under that contract. In some suspension provisions, if services or activity is not resumed before that suspension is over, one or both parties may have an option to terminate that agreement. And those contracts may lay out what funds are due or owed by either party if there is a termination for suspension or termination under any of the terms of the contract. Another provision that is a very significant catch-all provision that's usually embedded at the end of that contract where people aren't really reading, they're just ready to get to that signature page, is your force majeure provision. It's a unique sort of term that basically means if there are circumstances that are beyond the control of the parties, large societal circumstances more often than not, that prevent one or both of the parties from performing their obligations under the contract, that then that party will not be held responsible. And often that contract will either come to an end or those obligations will simply be waived or suspended. The types of activities that are considered subject to the force majeure provision are often acts of God, they can be acts of war, and they can be acts of government, which this COVID-19 pandemic covers two of those main ones, sort of an act of God and also acts of government in terms of shutting down businesses and requiring non-essential businesses to not conduct business. In those contract provisions, beyond your termination, suspension, and force majeure provisions, you also want to pay a lot of attention just to how the cash flows in a contract. Payment terms can either help during a crisis or they can hurt during a crisis. Understanding the timeline for money to flow into your business, as well as the timeline for money to flow out of your business, can help a business survive a crisis, pivot during a crisis, and also hold on to financial resources that are much needed to get through that crisis. A final contract provision that you might want to consider are risk of loss provisions in a contract. Risk of loss provisions specifically detail who in the contract is going to bear the responsibility and bear the risk if there is some sort of damage or injury or claim while the parties are performing in the contract. This type of provision often comes into place when you're discussing the shipping of goods, when you're discussing the creation of something on behalf of a customer. The risk of loss can shift from the manufacturer to the purchaser, either at the point that it is shipped out from the manufacturer, while it is in transit by a carrier, or once the product is received by the customer. Similarly, the risk of loss in, for example, construction matters and construction projects may sit with the contractor until the project is completed and accepted by the owner. That means if there's damage to the property, if there is destruction of a project while that process is still going on, the contractor is going to be responsible for that loss and responsible for replacing that performance. That's where oftentimes you'll see insurance coming into play, something that we discussed in part 1 of this series. So to recap, there are some key contract provisions that you want to look at to see how you can shift the obligations or get some relief from the obligations of your fixed costs. Those are understanding your cash flow provisions in your contract. That's understanding how your contract can be terminated or suspended. And that's also understanding how a catch-all provision like force majeure may help relieve obligations to perform by both or one of the parties in your contract. And for more information, please feel free to reach out to the attorneys at Smithers and Ume-Nwagbo by reaching us at stulawgroup.com. You can also find us on Facebook or LinkedIn. And this has been a note from my Legalpad.